Today's class. I see it is already 2 minutes past 9, so I'm going to proceed with today's lesson. Again, I just want to remind everybody that we will be recording the class so that I can post the link afterwards for the students that have not been able to attend the class. So today's class will cover Unit 2 and Unit 3 of the Study Guide FOR1502, the first section. And again, I'm going to be your lecturer taking you through the session today. So if at any time something goes wrong or you want to ask something, please raise your hand and I will attend to it, but we will be having a Q&A after each unit that I've discussed. If you do not feel comfortable to speak on the open platform, you are more than welcome to jot down a question or a comment in the chat box. So today's outcome for the lesson. Yes, Doc Machete. Hi, Petrus. Petrus, I can't hear you. Petrus, I'm unable to hear you. I can see your hand. Oh, it seems the connectivity is either very poor on my side or your side because I'm getting... Prof. Doc Machete, I'm not hearing you at all. I'm going to ask that you perhaps put your comment in the chat box for us.
Was not receiving
Doc Machete, I cannot hear you at all. So colleagues, with your permission, Felicia, are you able to hear him? Because I see Felicia is also there. Yeah, he's breaking up terribly. Okay, I want to share my the presentation again because it seems that it got lost now. So let me just go and look for it so that I can share the right one with you. My apologies for that. And then we can get back to today's class. Dr. Machete is actually my secondary lecturer, and I think, I know that is why he was in the session as my secondary lecturer. Okay, so let's carry on. Looking at the outcomes for today, for this morning session, for this study unit specifically, we want to be able to determine what is a civil, a criminal, and a departmental investigation. We want to consider what are the mandates, what is a mandate to investigate. We need to be able to understand what is the standard of proof and the burden or the onus of proof. We need to understand what procedural fairness and substantive fairness implies. And we are going to look at the investigative report. We are going to talk a little bit about the rule of law. the 5 questions rule that you do in FOR1501, as well as the generic investigative process, what a generic investigative process looks like. So today we're going to be focusing on the criminal justice system in South Africa to meet these outcomes. We're going to consider the different tribunals. We're going to ask ourselves whether justice is a Western concept. We will be dealing with the investigative cycle, the investigative mandate or a letter of engagement, the investigative report, and then those important concepts of procedural fairness, substantive fairness, standard of proof, and then burden or onus of proof. You will notice that I don't have the 5-question rules in there, basically because it's dealt with in FOR1501. So I'm just going to link you back to that when we do get there. So South Africa is a constitutional democracy. This implies that the Constitution is the highest law of the land. Have I stopped sharing my content? No, I have not. So the Constitution is the highest law of the land, and that is what we... Felicia, are you able to see? Okay, awesome. I'm not sure what's going on with the slide view this morning, but hopefully I'll get it sorted out now. So the Constitution is the highest law of the land, and this implies that we are also, as a country, bound by the rule of law. This means that no person is above the law. In other words, the law in our country is applicable to everybody. So South Africa has a 3-tiered government system. In other words, our government departments are at provincial level, national level, provincial level, and local level. And as such, our government departments are also divided into clusters, because government departments on their own cannot do everything that they are responsible for. So the government departments whose mandates are complementary, they have been put into clusters. And law enforcement falls within the justice, crime prevention, and security cluster, which consists of the South African Police Service, the Justice Department, and the Department of Correctional Services. You may recall this image from your study guide. It's in it we represent, or we give you an overview of the rule of law. Now, the rule of law is a principle of governance in which all persons, institutions, and entities, whether public or private, this includes the state, are accountable to laws that are promulgated publicly, equally enforced and independently adjudicated, and which are consistent with international human rights norms and standards. Thus, the justice system in South Africa must function within this context. So when crime does occur, this is when the criminal procedure process is activated. And let's say person A breaks into your house, steals your computer, you go to the police station and you report the case at the police station, and a case is opened up and you get a CAS number, and then the detective is assigned to the case. The detective does the investigation. Let's say the culprit is arrested, and then the trial starts. Now, in a criminal trial, one of the primary role players is the prosecutor. And criminal trials in South Africa are adversarial by nature. So the trial is like a competition between the state, which is represented by the prosecutor, and the defense, which represents the accused. We are now going to consider the 3 primary platforms for legal arguments. Sorry, my dog just wants to go out. My apologies. The joy of having animals for children. So before we get there, I thought I'd share this with you quickly. You know, there's a lot of jokes about lawyers, and from this meme, I thought it was very funny. Can you guess how many lawyer jokes there really are? There are only 3. The rest are true stories. So, yeah, there's a lot of jokes that get told about lawyers, and some of them are very tongue in the cheek. You get incredibly good ethical lawyers out there, but then you also get people who basically sell their souls to the highest bidder. But let's get back to the 3 tribunals. Now, a tribunal is basically just a forum. So we can say the three forums for legislating or making decisions in South Africa that we will be dealing with. And we will be talking about number 1, the criminal court. It's this one. We will be talking about civil court, civil cases, and then disciplinary hearings. These are the only 3 platforms or tribunals that we will be addressing in FOR1502. So the criminal court. Now, criminal offences in South Africa are based on South African law and international standards. The standard of proof, in other words, the standard at which proof must be held or must be presented, is beyond reasonable doubt for a criminal case and for a criminal trial. These investigations are undertaken primarily by the South African Police Service. In some companies, it's being done by in-house investigators, but the in-house investigator can never take the case to court. It has to be a police official that liaises with the state prosecutor, who then presents the case in court. In a criminal trial setting, it is the state that institutes prosecution against the accused. It's never an individual. The police official represents or he's the docket bearer, but the state is the authority that institutes the prosecution against the accused. Civil action is a little bit different to criminal trials. Civil action is instituted by a private person, let's say an aggrieved person, or also called the plaintiff. And this person institutes a civil action against a defendant. Now, this usually happens when the possibility of a criminal trial, or when the offense or the complaint is of a civil nature. That is when a civil trial would happen. Civil cases are incredibly expensive, and they can take very, very long. Civil cases require the presence of a lawyer. They may also make use of an investigator to gather evidence for the trial, but the lawyer presents the evidence, and the standard of proof in a civil trial is on a balance of probabilities. So in a criminal trial, it was beyond reasonable doubt. And in a civil trial, It is on a balance of probabilities. The last tribunal we will talk about is that of the disciplinary platform. Now, action results from a disciplinary transgression in contravention of a company policy. Remember, we said yesterday that unless there is something written in the disciplinary policy that says your conduct is unacceptable, and unless that rule is not there already, you cannot be charged for something that isn't in policy. So that the policy must say you may not absent yourself for 3 days or more from work without a sick note, and you have done so, and then your company can institute disciplinary steps against you. Now, these matters in terms of disciplinary misconduct are governed by the Labour Relations Act. We did refer to this yesterday. Investigations are usually done by an in-house investigator. The investigator will present findings of their investigations in a form of an investigative report, and the standard of proof is on a balance of. The management will take a decision about the further action or decision on further action in terms of what the investigative report, but that will depend on company to company to company. Will only be criminal. Even law or statutory law. My apologies, everybody. I seem to be having a break in connectivity this side. I see we're back. So customary laws cannot be found in written pieces of legislation since they are unwritten laws which apply to certain culture groups or ethnic groups. Criminal investigations are mostly undertaken by the SAPs. I did say in some instances, in-house investigators or even external private investigators are hired to conduct an entire investigation for a company. Once the investigation has been completed, then the company will open a criminal case and hand over the entire set of documents with all the evidence to the SAPs, and this will be included in the docket, and then it'll be taken through the criminal justice process. It's quite possible that there are more external than in-house investigators in South Africa. External investigators often take statements and open cases, and their reports are also used in criminal, civil, and disciplinary hearings. Insurance companies conduct a large number of investigations, and they follow the same pattern as we do. The only difference is that the insurance ombudsman's decisions are usually the one that's accepted, and this is a civil process. Very, very few of their cases end up in court. Now, let's pause for a moment and ask ourselves this. Before the white man came to Africa, because the colonizer was white, was there justice here? Or was the continent lawless and wild? So let's think about that for 5 seconds. I'm sure you've had some time to think about this. Prior to colonization of Africa, traditional justice systems were in place to deal with community-level disputes. In South Africa, we have the term lekgotla. It's a Tswana term, and it means a public place where consultation and judicial proceedings are conducted. There are also many papers you can access and read, which prove the extent to which there was justice in Africa. I find it rather unfortunate that this is not recognized simply because the form of justice did not align with what the colonizers thought was justice. The white man brought their own form of justice, which in all honesty, when you look back, can we really call what they brought to Africa justice? So I leave that question unanswered. Bear with me for a moment. My slideshow is struggling to go to the next slide, in which we will discuss the departmental trial. My apologies. It seems as if all sorts of ICT gremlins are really I'm going to try and reshare. Let me stop presenting. Okay, let me reshare. So that we can carry on with the class. Sure, it seems as if really the ICT gremlins are out to stop us today. Okay. Okay, so far so good. And we are at the departmental trial. Awesome. So departmental trials are instituted when the misconduct committed by the person is of such a serious nature that a trial is warranted. Guys, a departmental trial is a serious, serious thing. You can end up losing your job after a departmental trial has been concluded. So before a decision is taken to institute a departmental trial, the company must be sure and must have set out that this type of transgression will result in a departmental trial. Now, the Labor Relations Act makes provision for departmental trials. And when an investigator is tasked to undertake such an investigation, they are given a specific mandate. And this is usually based on a specific allegation. On completion of the investigation, the investigator must produce an investigative report to the relevant manager. And then this report will contain recommendations based on the results of the findings of the investigation. Now, it's very important to note that not all cases of disciplinary misconduct warrant an investigation. After the investigation has been done, your recommendation might be to give the person a first verbal warning or a first written warning. That is also possible. You may make recommendations, but you are never the person to decide this person is charged, goes to a departmental trial, or no, it will be not a departmental trial. Other restorative measures will be applied. That is not your job. Depending on the policy of your company, that decision will fall either with the internal line manager of internal investigations or the HR manager responsible for labor relations matters. So when the misconduct is not serious, the immediate supervisor may institute the relevant disciplinary action against the employee. But this must be done with due regard for the audi alteram partem rule. This is a very important concept. It means that the supervisor must first hear the side of the alleged transgressor before making a finding. So if person A complains about person B, the line manager must first hear, after having heard person A's side, must first hear person B's side. Failing to do so would be in contravention of procedural fairness, which simply means not following a fair procedure when deciding about the next step of a departmental process. Now, this graphic comes from your study guide. I'm sure you've seen it. It shows the normal flow of a criminal investigation, but it is equally suited for a private investigation or an internal investigation in a corporate environment. Be aware that in a corporate environment, the success of the investigator usually depends on the investigative report submitted at the conclusion of the investigation. Not all investigations end up in a tribunal, either in a disciplinary hearing or in a civil or even in a criminal court. But it is vital that you conduct each investigation as if you were headed for a trial in a criminal court. So try and ensure that your evidence is collected at the beyond reasonable doubt level. So in private and corporate environments, investigations are conducted according to a mandate or a framework. As a result, the investigation will be specific and focused. In view of this, all investigations have to be conducted within the scope of the law, applicable disciplinary codes, and the mandate set by the manager or even the client, if it's a client that is hiring you as an external investigator to come in. A person may lay a complaint, and this complaint is put down in writing, and then you receive this mandate, and you look at this mandate and you think, what? Sure, this doesn't warrant an investigation. We cannot make decisions like that because already you have put yourself on the back foot to say, this is a stupid complaint. No, we cannot do that. You may not at any time assess the veracity or the value of the complaint. You must take the complaint at face value. It is an allegation being made at somebody. The somebody is innocent until proven guilty. It's not, you are not the judge and jury. Your job is to investigate and to find the truth and to get the facts of the story. Your investigation is going to end up in an investigative report. Your study guide contains a pro forma of this investigative report from page 28 until page 30. In each of the blocks, you will see what it is that you must write there. So let's take a look at the first one. The allegation or the issue being investigated. Yeah, you're right. The allegation is that Mr. A failed to report for work on Monday, 4th of June, 4th of July, Tuesday, 5th of July, and Wednesday, 6th of July, 2022. Mr. A did not call his line manager, so it is alleged that he was absent from work without a lawful purpose. Name and designation, this is your details. You're the corporate investigator. Name of the appropriate complainant. This will probably be the line manager of Mr. A. And then, sorry, I see the previous one was the designation of the employee subject to investigation. So this is Mr. A's details. Here are your details. In some investigations, the investigation is big enough to warrant a few investigators. But remember, time is money. And it's very seldom that money will be spent to do an investigation. Let's say person A defrauded the company of 10,000 Rand, and the company will not spend 30,000 Rand in doing an investigation where they lost 10,000 Rand. More often than not, they could take the person to a civil court, or they would cut their losses. And then if it's necessary, an HR support or link. So in other words, if there's an HR manager there that you are working with. The next heading is the background. I didn't put them all in there, but you can go and look at it in your study guide. We are going to, in the assessment 4, we are going to do the investigative report. You are going to get a case study, and you are going to have to write an investigative report. I will post under additional resources an example or two of investigative reports written for companies, so that you can see there isn't only one format. This is but one format I've put there. Your company might make use of another format. Use the format that your company prescribes. For everything you write in this report, anchor what you are doing in terms of day, date, and time. Somebody is going to read this report and have to make a finding or a decision. You cannot make broad sweeping statements. John McIntyre didn't come to work on Monday, Tuesday, and Wednesday. That is insufficient. In non-compliance with the absenteeism policy, John McIntyre did not report for work on Monday, 4 July, Tuesday, 5 July, Wednesday, 6 July, 2022. His office hours are from 8 to 4. He did not call his line manager. So you have to detail what it is that you are writing or capturing or finding in your investigation. We have spoken about a couple of concepts in the preceding slides. These concepts are very important within a legal context. The first concept is that of procedural fairness. Look at the term. It talks about the fairness of a procedure. So in other words, the procedure that was followed or instituted to either investigate and then institute disciplinary proceedings must be fair. If you disregard procedural fairness during an investigation, it's going to harm the case when a disciplinary trial is instituted. One of the most important aspects of procedural fairness is the audi alteram partem rule, is to hear the other party's side. So you can never conduct an investigation against person A without going to person A and finding out what is your version of events. What is your side of the story? We may never take sides as investigators. As investigators, we have to be objective. We have to stand on the outside and we have to look in. You will recall yesterday I spoke about If you are mandated to do an investigation and you have a connection with the person being investigated, you have to recuse yourself from that investigation. And as I've said, I've referred to the Audi Alteram Partem rule. So please remember procedural fairness. It's about the fairness of the procedure followed. That must be, the procedure followed must be fair, and you must hear the other person's side, the side of the person against whom the allegation is leveled, and that is the Audi Alteram Partem rule. Substantive fairness is not to be confused with procedural fairness. Substantive fairness has got to do with the reason for the disciplinary action against an employee. The department or employer must ensure that the reason for instituting a disciplinary action is fair and that there is a valid reason for instituting disciplinary action. For example, if the employer is allegedly guilty of misconduct. This is referred to the concept of legality, which means that a person can only be charged, convicted, and punished for something that was designated an offense or a disciplinary misstep before the incident occurred. Furthermore, the person who's being charged must be aware that what they did was contrary to the disciplinary code. So in other words, the first time a new person comes to your place of work, they have to be provided with a disciplinary code so that they can see this is the time you come to work, this is the time you can go off. These are your hours. If you smoke, these are your smoke breaks allowed. These are your toilet breaks allowed. If you go on sick leave, this is a procedure. If you go on vacation leave, if you commit misconduct and you are absent for 3 days or 2 days or even 1 day in some cases, you can be making yourself guilty of disciplinary misconduct, and the company can take steps against you. And then the person does this. How do you know? Where are you going to prove that the person was briefed on these policy issues? It's very important that when they do the onboarding or the acceptance of the new person now into the company, that the briefing that's given, that person signs some form of attendance record to say, I've attended this session by HR and I am now aware of the disciplinary code of conduct of UNISA. So that when you get to this stage, the substantive fairness stage, where the employee can't say, but I didn't know, I was unaware, then you have that proof that the person was indeed informed. The next concept which we have to understand is the concept of the standard of proof. Now, the standard of proof refers to the strength or the amount of evidence that you must bring in a case to secure conviction or a positive result or to win your case. In the civil case, the standard of proof is much lower than in a criminal case. So in a civil case, you only have to prove, remember, it's on a balance of probabilities. So you only have to prove that the plaintiff's version is more likely to be true than the defendant's version. This is called on a preponderance of probabilities or a balance of probabilities. The standard of proof is the same for disciplinary matters. This illustrates the importance of being able to determine what and how much you need to bring your case, bearing in mind that the standard of proof, again in disciplinary matters, is the same as civil cases, but lower than a criminal court. Criminal court is beyond reasonable doubt, and civil and disciplinary are on a balance or preponderance of probabilities. Now, here we have another term, the burden of proof or the onus of proof. This was the standard of proof, or in other words, the strength or the amount of evidence. At what standard must your evidence be? And this is now the burden or the onus of proof. There's a difference. The burden of proof. What is a burden? A burden is something that you carry. Nah? So the burden of proof it refers to the side that must prove their case in order to succeed. As a rule, the aggrieved party must prove the case. So in other words, in a civil trial, the aggrieved party is the plaintiff, because the plaintiff takes the person against whom his case is to civil court. Sorry, I just need to have some water.